Shalom, this is your Ark. Yah is magnified. Coming back with another informative video. I titled this video, The Child is Property of the State. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, so I'd like to give a shout out to my aunt Tony for sending me this document today. This is a very powerful case. It would be nice if you all, take the time out, Google this case, read over it so you can get some more understanding of what's really going on, okay? I told you all I wasn't doing that much educational videos this year. This year is going to be more of a show and prove. But, since Tony asked me to go over this and share this with you all, I'm going to go over some of it, not the whole thing. You all can read the whole case when you get time, okay? But as for now, I just want to go over some important parts, just further prove that the child belongs to the state. Whatever state you in, excuse me, whatever state you in, whatever state you in, the child belongs to that state, okay? It's property of that state. Okay, but let's pick this up at the top. As you can see, it's in the Supreme Court of Vermont, Catherine Powers versus the Office of Child Support. Okay, so Catherine, she was a recipient of child support, but she got upset with the agency and filed a lawsuit against them because she felt as though they was not enforcing the order as much as she would like them to enforce it. They wasn't collecting on the debt. The guy wasn't paying him a dime, and he owed like $120,000 in arrears. And when he went to court, they found that he willfully didn't pay child support, but he still wasn't arrested. I guess because his actions ain't showing that he was volunteering. So that's a good thing. But she had got mad, so she wanted to sue the agency and felt as though that the agency wasn't doing its duties that she applied for with the services, okay? So let's pick this up at the top to just get a quick overview of the case. Right? It states, top line, plaintiff Catherine Powers appeals from a superior court judgment dismissing her claim against defendant, State of Vermont, Office of Child Support, OCS, and 11 of its current and former employees for failure to state a claim upon which relief can be granted under VRCP 12B6. Then it says specifically, Powers claims that the Vermont OCS failed to adequately represent her in seeking enforcement of child support orders against her ex-husband. She argues that the court erred in determining that her claims against the state and OCS were barred by the doctrine of sovereign immunity and that her claims against the individual defendants were barred by 12 VSA subsections 5602A. She claims, too, that the court erred in failing to consider her breach of contract claim. We affirm. So when the court say that we affirm, they basically state that they go with the lower court's ruling. So they agree with what was ruled in the trial courts, and so they basically deny her appeal. But let's get let's go a little bit deeper so we can read. I just want to show you all that the child is indeed property of the state. Okay, it's well known that the child is property of the state. Okay, so we all need to go in there and handle our business accordingly. But it states Vermont's top line, guys. Vermont's statutory scheme was not intended to benefit individual children and custodial parents, but was intended to benefit Vermont society as a whole. Okay, so now we see who the beneficiary is for child support. It's the state. The state is the beneficiary of everything. Okay? It's not for your benefit, it's for their benefit. They do everything for their benefit. That social security card is for their benefit. That birth certificate is for their benefit. To turn you into their slave. That's benefiting them, not you. But let's continue. Vermont law does not create a specific duty owed by OCS to any particular group of persons. As we noted in Noble, a collection agency is engaged particularly in the business of collecting debts owed to others. Excuse me. Right? So now they're basically stating that child support is a collection agency. But this collection agency sole purpose is to collect the debt that was owed to others. So they basically believe that you owe Vermont or your child's mom some type of payment for an alleged debt. And they're going to do whatever it takes to collect on it. But let's continue. Its sole contractual duty is to utilize its best efforts to collect the debt. Case law to back it up. Then it states, in contrast, in bringing hold on. In contrast, in bringing support actions on behalf of families, OCS is required by statute to be guided by the best interest of the child whose benefit the action is taken. So now, how could it state that when it just stated at the top that Vermont statutory scheme was not intended to benefit individual children? But then when you read down here, it states, quote, be guided by the best interest of the child. Okay, so now it have to be either or. It's going to be the best interest of the child, or it's not going to be the best interest of the child. Okay, basically what it is it's the best interest of the state who owns the child. That's why it's saying it's not in the best interest of individual children. No, it's in the best interest of the state. The state is the beneficiary. Okay, that's why it states be guided by the best interest of the child for whose benefit the action is taken. When it states up here that, let me zoom in. It states right here that top line, but was intended to benefit Vermont society as a whole. Okay? So the child belongs to the state of Vermont. But let's continue to prove this. Before we can all see. Right? Oh, hold on. Before we can all see. Let's continue to prove this. Then it states, where was I at? Right here. Top line. It states collecting debts owed to others, its sole contractual duty is to utilize its best efforts to collect on the debt. In contrast, in bringing support actions on behalf of families, OCS is required by statute to be guided by the best interest of the child for whose benefit the action is taken. Further, the legislator has declared that the paramount interest of the state of Vermont is the welfare of its children. Of who children? Vermont children. Not the custodial parent child and not the non-custodial parent child. No, Vermont's children. The child belongs to the state. It's property of the state. It gets no clearer than that. Let's read it again. And quote, the paramount interest of the state of Vermont is the welfare of its children. The Office of Child Support is carrying out its responsibility shall be guided by the best interest of the child, but not the economic interest exclusively in an action for child support. So again, the child belongs to the state. Remember I told y'all in my last testimony video, render unto Caesar the things that are Caesar's. Okay? They're not talking about your living, breathing offspring when you go into these courts. No, they're talking about the documentation, the birth certificate. That's their property. That's why they say if you sign the birth certificate, then you are responsible for paying for child support. Not because you had the child. No, it's because you signed their documentation, which is the child, which is the birth certificate, which has the state name at the top of the birth certificate. So if this child was born in Vermont, because this is a Vermont case, then Vermont is the child's custodial parent. Okay? The state has sovereign guardianship over the child. That's how they can appoint custody. Because how else could they appoint custody over something that they don't own unless they own it? I can't have my car and say, or have someone else's car and say, well, I'm going to give your car to so-and-so. No, you can't do that. I have to own the car outright to appoint who I want to take care of my car. Okay? Same thing with the state. The state owns the child outright. They are the sovereign guardianship of the child. And because they are the sovereign guardianship of the child, which is the documentation, they can appoint who they want the child to reside with. They can appoint the custodial and the non-custodial parent. It's that simple. It's their property. They're not talking about your living, breathing child. You just attach your living, breathing child to that property. And then you go in there arguing on behalf of it, thinking that they're really talking about yours, your offspring. No, they're not. Give them back their property. Why are you going in there arguing about a child? If you know they're not talking about your living, breathing child, stop going in there arguing. I tell you all, stop arguing. The facts are on the moon. They can care less about the facts. Okay? Never argue the facts. Just stick to the point. Okay? We know the truth. We have to let them know the truth. Okay? They know the truth too, but they want to see if you know it. If you can go in there and articulate this stuff, if you can bring proof to back it up. If you in Vermont, this all the proof you need. Copy this case law, copy this right here, and it states the paramount interest of the state of Vermont is the welfare of its children, not the welfare of John Doe's children, Jane Doe's children. No, of Vermont's children, because Vermont is the sovereign guardian. But let's continue. It says the purpose of the OCS does not change depending on whether or not the petitioner is receiving public assistance or whether the petitioner has assigned his or her rights to the agency. In neither case does the service provided by OCS flow to an individual, but instead it flows to the welfare of the state. You see what I mean? It flows to the state. The state is responsible for the child. Okay, it's in the best interest of the child. When they say it's the best interest of the state, the child is property of the state, so it's the best interest of the state when you pay child support. And it states right behind that, it's children. Again, the state's children, not yours. This is, like I tell y'all, man, I done enough teaching, I'm going to stop it right here. I done enough teaching, man. I just want y'all to see this truth. Pay close attention to what I'm saying, man. You have a lot of people giving out information, but it's just more than just filing documents into the court. You have to know. You have to study this, okay? You just can't, you have to know when to use the straw man, when not to use the straw man, when to file a response, when not to file a response, okay? You have to be able to play the game. Learn, okay? Like I said, this is a nice case. But hold on. Let's scroll up right here. I want to read this to y'all too. It states, I told y'all this in my videos. Go back and watch it. It states, the Tort Claims Act is an exclusive right of action, 12 VSA, subsection 5602, and claims based on the act or omission of an employee of the state acting within the scope of employment lies against the state of Vermont and not its employees. Didn't I tell y'all, man? File your suits against the state. Stop playing these games, man. Hey, if you live in Vermont, Vermont has caused you child support injuries, bring your claim against the state. Okay? Remember, it don't say bring no complaint. It's called the Tort Claims Act, not the Tort Complaint Act. File your claims. Okay? Why? Because they're causing injury and harm. Know this fact. This is simple facts. But hold on. Here are exceptions, though. Also, it says there is one exception. When the claim is of gross negligence or willful misconduct, an action may be brought against an employee, even if the act or omission given rise to the claim within the scope of employment. So again, you can bring certain suits against the individual employee. But I'd rather sue the state because the state got more money. Okay? And the only time you can bring a suit against a state employee is if it was out of gross negligence. Okay? But majority of child support is not out of gross negligence. They're all acting in their scope of duty, willfully causing you harm and injury. Willfully. Start filing your suits, man. Okay? But let's read the outcome. It states at the bottom round down here, finally, the last little two-sentence paragraph, it says, finally, Powers alleged that OCS caused her harm for failing to provide her access to her files, thus preventing her from taking responsible actions to mitigate damages. This claim is made against the agency and not any named individual. Thus, it is defeated by sovereign immunity. Okay? So now you got to understand, they will throw sovereign immunity out there if you're not bringing your claim right. I tell y'all, you have to study. You have to know. You have to be able to bring it. Remember, I tell y'all, these people can only sue in name and be sued in name. So if you're bringing them to court, you're not going to go in there and argue the straw man. Okay? You have to know when to use these things and when not to use them, okay? You have to be ready. You have to have your mind right. Like I said, and you don't have to run into these courts every time to get remedy. Get remedy on the outside as much as possible. And when that fails, then you'll be ready to bring him to the court because you can provide that evidence. Okay? So again, that's all I'm going to do for today. as I stated before, let me read it one more time so you all can see that the child is property of the state. It belongs to the state. Give them back their property if they want it, and you live your happy life. Okay? But let's continue. Let's go right there real quick where it states that top line, okay, very top line, it says further, the legislature has declared that the paramount interest of the state of Vermont is the welfare of its children. Okay? But let's continue. Out of the mouth of two witnesses. So we have to say that it's children twice to make it true, right? Not one witness. We need two witnesses saying the same thing. So let's continue. The Office of Child Support is carrying out its responsibility, should be guided by the best interest of the child, but not the economic interest exclusively in an action for child support. Case law to back it up. Well, not case law, but state code to back it up. Then it states the purpose of OCS does not change does not change dependent upon whether or not the petitioner is receiving public assistance or whether the petitioner has assigned his or her rights to the agency. And in neither case does the service provided by OCS flow to an individual, but instead it flows to the welfare of the state, its children. Okay? So again, it's going to the state and its children. That's it. Why? Because the child belongs to the state. That's it. That's all. That's how they can tell you all what to do with your property, with your living, breathing offspring, because you attach them to them documents. So again, that's all I'm gonna do for today. Ain't no point of going in there arguing these facts, guys. I cannot stress this enough. Y'all continue to fight. Don't quit. Don't give up. Okay? Everybody keep their heads up. The truth is here. The truth is out there, man. Y'all have to read it. Y'all have to search for it. Get this truth, man. I keep telling y'all, this is not what you believe it to be. They are not talking about your living, breathing children, man. Don't go on these courts confusing it, man. Because once you do, you get all emotional, you start acting out your emotions, and then you're in trouble. Okay? You have to know what's really going on, man. Okay? So with that being said, you all be blessed. If you need my help, hit me up at my email at y'allismagnified@gmail.com. If you serious, let's get this thing moving, man. Like I said, I'm trying to help as many brothers out as possible before I stop. I don't know how long I'll be doing this, but hey, while I'm doing it, I'm trying to help as many brothers out as possible. So again, that's all I'm going to do for today. You all have a wonderful weekend. Shalom.